I am a deputy city attorney in the San Francisco City Attorney's office. And generally what our office does is defend the city. So we advise all of the city agencies, we defend any agency that gets sued or any individual who gets sued, we review all of the city contracts. We are generally the city's lawyer. We are not, however, City College's lawyer, because City College is not a city agency. City College is its own independent entity with its own governance structure and is not a part of the city. So we don't represent City College. We do, however, have a very special charge, and the team that I am on is called the Complex and Special Litigation Team, which I love. You know, I am complex and special. It's the best title ever. I am a deputy city attorney on the Complex and Special Litigation Team. And a big part of what that means is that there is a special law in California which gives the Attorney General and certain city attorneys, including the San Francisco City Attorney, the right to civilly prosecute and take to court any entity that is engaging in unlawful, unfair, or fraudulent business acts or practices. And all of those things are defined very broadly. So if anybody is violating any law, any state law, federal law, local law, federal regulation, anything, that counts as unlawful. And unfair is a little tougher to pin down. There's a lot of different ways that people describe what unfair means. But essentially, if you're doing something really bad and it doesn't have any corresponding really good benefit, we can make an argument that that's an unfair business practice that we, the city attorney's office, are authorized to bring to court. And when we bring those cases to court, we're not bringing them on behalf of the city. We're not bringing them on behalf of the City College. We're bringing them on behalf of the people of the state of California, which is another really great thing about my job. So I get to represent the people of the state of California in complex and special litigation. So when we bring all sorts of cases under this authority. We bring cases against payday lenders who are charging exorbitant interest rates. We bring cases against, when you eat in a restaurant here and it has those surcharges on the bottom for healthy SF, and restaurants were not actually giving that money to their employees, we can do that under this law. We're going after Monster Energy for marketing their highly caffeinated beverages to young children. So anything that is unlawful or unfair, we on behalf of the people can bring a case. And so that's what we did here. So we are not representing the school, we are technically representing all of you who are the people of the state of California. So we sort of became involved in this really because or specifically Dennis Herrera, the city attorney, saw in the paper after the termination decision last July that the ACCJC had decided to terminate the accreditation. And he just looked at that and said, well, this seems like it's terrible. This seems like it's going to be a really bad thing for the city and for the people. And we need to look at this and we need to see, what's going on. How did this happen? Is there anything funny going on that we should be involved in and that we should be looking at? And that's what we did. We started digging around and looking at the ACCJC's actions. We looked at the complaint that was filed by the AFT and a lot of the teachers and the students here. And we sort of dug around and saw, this really looks like there are both unlawful and unfair practices that have been engaged in by the ACCJC. It looks like they broke a lot of their own rules. They broke a lot of the federal regulations. They didn't put the teams together correctly who came out to evaluate the school. They didn't include enough teachers. As I'm sure you all know, they did include Barbara Bino's husband on the team. They were, at the same time that they were evaluating the school, they were out there lobbying for a change in the open access mission that has been so dear to City College. And this really reflects, I think, a national debate. And this is what we really started to learn, that there's a huge debate, and it's not just in City College, and it's not just in California, but nationwide, about what is the role for community colleges. And should community colleges be open access to all who can benefit from education, which has been City College's mission, or should it be more narrowly focused on students with the best chance of success, defined pretty narrowly? And at the same time, they were looking at City College, the bastion of open access, They were arguing that City College's mission should be changed, and all of this struck us as off. And not just as off, but as unfair and unlawful within the meaning of the law.
Right.
So we filed a case under that very special law that gives us the power to do so. We filed a case on behalf of the people. 2 other cases have also been filed, and this is where it starts getting very complicated. So we filed a case on behalf of the people of the state of California under our special powers. The AFT and the teachers' unions and a number of individual teachers and students also filed a similar case. There's some overlap between the 2 cases, although we have slightly different focuses in terms of which specific violations we focus on. And we also are looking beyond City College. We want the ACCJC to be held to higher standards in their evaluation of colleges across the state, and to be held accountable to the public and to the Department of Education and to the laws. So not just in City College, but in colleges who are at risk all across the state. So we filed, the teachers union filed, and the Save CCSF coalition filed. Our case, the people's case, and the union's case were filed a little bit ahead of the 3rd case, and so I'm going to talk mainly about those 2 because they're the ones that have had the most action recently. So we filed the case in San Francisco Superior Court, which has a special department called the Complex Department, which obviously, since I am complex and special, I like my cases to be in the complex part. And this case was designated as complex, as was the union's case. So we were singly assigned to one judge named Judge Carnow, who took over both cases. So then there was a good amount of legal maneuvering that sort of became irrelevant. The ACCJC tried to remove us up to federal court. We said that's not right. We got that fixed. They sent us back down to state court. And then all of a sudden we realized that with all of this legal maneuvering going on, we sort of lost track of time a little bit. And suddenly we were coming up on the spring enrollment deadline, which just passed. And we were following the enrollment numbers and seeing that the funding for City College is tied to these enrollment numbers. And because of all of this noise that's going on and the lack of real understanding about what it all means and what this means for the future and the risks that it entails, the enrollment numbers were going down, right? And so there's the signs up all over, open, accredited, enroll now. But understandably, students and prospective students were afraid, right? They're afraid of, if I enroll here, are my credits going to transfer? If I enroll here, will I be able to finish here? What's going to happen with this loss of accreditation? So at that point, we realized, okay, we gotta do something, and we gotta do it quickly because justice moves slowly. Court cases can take an incredibly long time. My office just won a case against lead paint manufacturers who were not disclosing the fact that their lead paint was poisoning children, and so all of these children have lead paint in their houses, and now the city has to abate the lead paint. That case took 10 years. We don't expect this case to take 10 years, but it gives you a sense that these cases take a long time. There's appeals, there's legal maneuvering, things go slowly, and City College and the students at City College needed some sort of reassurance right now. So our office filed a motion for a preliminary injunction, as did the teachers union. So in both cases, there were 2 motions for preliminary injunction. And what a preliminary injunction is it's basically to press the hold button, to keep the status quo, keep the situation exactly as is until there is a chance for the case to be heard and the court to make an ultimate decision about the merits, whether we win or not. So ultimately in our case, at the end of the trial, what we're asking for is for the judge to vacate the termination sanction, vacate the show cause decision, and start over. Send out a new team that is properly comprised, that is not biased, do the evaluation right. And we believe that if they do the evaluation right, the result will be different. But we're not asking the court to make that decision. We're just saying, let's give City College the fair shake and make sure that the accrediting agency actually follows the law. So that's what we want eventually. But you can't ask for that at the preliminary injunction stage. All you can ask for at this stage is just stop everything in its tracks. Hold everything right where it is and don't let anything bad happen. Don't let anything change until you can decide whether we're entitled to that ultimate relief. So that's what we asked for, and that's also what the unions asked for. The ACCJC, not to let us have the last word in being the only people to bring motions, filed 2 motions of their own, one in each case. So in the union case, they filed something that's called an anti-slap motion, which is essentially a motion that you file when you say that somebody is trying to suppress your free speech through their lawsuit. So if you file, so their argument was, we have a right to lobby, we have a right to make decisions about colleges, in fact we have a duty to, and the union is trying to suppress our free speech by bringing this lawsuit. Against us, they didn't bring that, but against us they said, well, you know what, the court should abstain. The court shouldn't hear this case at all because there's an internal review process going on. We're looking at a review and then there may be an appeal, and there's all of these complicated federal regulations that govern the actions of accrediting agencies, and it's the feds who should be looking at this. And the feds, by the way, say that we're fine. They say we're fine, we have no problem. Sure, they found we had 17 violations of various regulations, but by and large they say that we're fine. So you, San Francisco Superior Court, what they basically said is, no offense, Judge, but you're not well suited to be doing this. You should hands off, don't hear the case at all, or at the very least wait until the entire review and appeal process is over, and then you can hear it. So I know some of you were there. We had 2 full days, which is amazing. We all thought, you know, for the preliminary injunction motions, we'd be there for 2 hours, and for the abstention motion, we'd be there for an hour. No. We got to court at 9:30 and we went till 4:30 on the first day. And then we went back at 10 o'clock and went until 3:30. And the judge let everybody say their piece ad nauseum. People went on and back and forth. The judge was great. He had read everything. He was well prepared. He asked difficult questions of all of the attorneys. And I think everybody walked out of the room. I know when I walked out, I said, I'm feeling pretty confident, but no matter what happens, I feel like we have made our points to this judge, and he has heard us, and at least somebody, right, somebody from outside has heard these arguments and is taking them seriously. And then the wait began. So, in the hearings, they argued all 4 motions, so in the union's case and in our case. We waited until early January. The judge issued the ruling that you've probably all heard about. And the judge denied both of the ACCJC's motions in both cases. So he said, I'm not going to abstain, I'm not going to grant your anti-slap, and then he turned to the preliminary injunction. And I brought a copy of the opinion with me, and I can leave it with Dave. And if anybody wants to look at it, I recommend that you do so. And one thing that the judge actually did, which I think is fabulous, and really respect him for doing, is at the end of his 50-page opinion, which is filled with legalese, and it's hard for even the lawyers to understand. I've read it 6 times, and it's a very complicated opinion. But at the end, he did a 2-page plain English summary of the opinion to explain what he did and why he was doing it. And if you look at nothing else, I recommend that you take a look at that and just see exactly how it is that he explained what he did. But in a nutshell, thank you. In a nutshell, he granted the people's motion for a preliminary injunction. He did not grant the union's motion for a preliminary injunction, but as long as we have one, that's giving us the cover that we need for now. And what he really focused on, and a lot of students and faculty were critical for this at the preliminary injunction stage and will be critical for this down the road, he focused on the harm. He focused on the fact that if City College were to lose its accreditation and were to close, the harm to students and to the city would be immeasurable. People would be forced to try to find different schools that they may or may not be able to afford, that they may or may not be able to commute to. The city actually relies on City College to train city workers. There's such a role that City College plays. It educates our workforce. You all are the future workforce of San Francisco, and the college is producing well-trained, well-educated people who are critical to our business and to our economy. And the judge looked at all of this because there's two factors you consider in deciding whether to grant an injunction. The likelihood that you're going to succeed on the merits of the case, and the harm if you don't get this preliminary relief. And the court balances those two things. And he said, likelihood of success? Yeah, there's a possibility that you're going to win. I have some concerns. He had some more concerns about the union's case than the people's case, because we have a lighter burden when we are representing the people in our special authority. But he said, yeah, there's a chance that you're going to win. You're going to be able to show that what they did was wrong. And when you look at the balance of the harms and the huge harm that would befall these students, and I think for those of you that were there, I think having a packed courthouse filled with people who came out to show the judge, this matters to real people. This is not happening in a vacuum. This is affecting hundreds of people who care enough the day after Christmas to come out and show our support. I really believe influenced the judge to make him realize this is a really serious issue. So he granted our motion and said, I think you could win. The harm, if I don't grant this injunction, is really high. So all things considered, I'm pressing the pause button. And I am not allowing the accrediting agency to terminate City College's accreditation unless and until we get to the end of this case and I have made my final decision. So we are far from done. It was a huge victory. We celebrated mightily. There was much rejoicing in the city attorney's office that evening. There may have been some whiskey drunk with the city attorney. And then, the very next day, Dennis, the city attorney, I have a call from him saying, okay, I want you in my office at 10 to talk about our next steps. What are we doing now? I said, can't I coast on this win for at least a couple days? He said, no, what's next? We got to talk about what's coming next. Because this is really just a reprieve, right? This is just, we're going to wait and see what happens. So now we are going to get ready for a full trial. We have a hearing at the end of this month on the 29th to talk about when that trial will be and what that trial will look like. We are going to propose that the trial be in October, which will give us enough time to conduct discovery, is what it's called in a case, which means you get documents and you get information from the other side. So we have served them with discovery requests, asking them to give us heaps of documents. We are going to seek to depose, to interview the commissioners and the members of the evaluation team to see if we can get to the bottom of what was really going on in this process. They're going to fight us every step of the way. They have already objected to a lot of our requests and said, we don't think you're entitled to that, we don't want to give you that. So we'll have a lot of hearings probably before the judge fighting about what documents and what questions we're allowed to ask. So we need time to do all of that. We need time to talk to all of you. The unions are going to be doing the same thing, and the Save CCSF Coalition is going to be doing the same thing to build our case. Because now we're going to have to go in and prove to a judge that something was hinky in this evaluation process, that they acted unlawfully, they acted unfairly, and as a result of that, you should start the process over. Right? The harm that we are alleging is the harm of not getting a fair shake. And we believe that the proper remedy for that is a fair shake, is to go back and redo the process over again. How much are we going to have to get into, is City College worthy of accreditation? We don't know yet. We're prepared to fight that fight if we have to, and we think that we would win it. But our position is that doesn't even matter at this point. Let the accrediting agency do it right and let them come to that decision on their own. So that is what, when Dave invited me, I was thrilled not only to be able to talk to you, but to open up the dialogue for all of you to talk to me, so that as we're building this case, we can hear from you, our clients, and present the strongest possible case that we can to the judge. So that's sort of where the cases are. While that's all going on, the accrediting agency has also been battling with the Department of Education, which has found it to be in violation of several of its regulations. It has come under fire from the state legislature that has demanded an audit and said some very unpleasant things about the accrediting agency and its leadership. So they are sort of fighting on all fronts. We think that is all great, that there's a lot of things happening that can all proceed in harmony. The DOE can do its thing, the legislature can do its thing, we can do our thing, the union can do its thing, Save CCSF can do its thing, and City College can do its thing. right? I mean, there's been a lot of talk about where is City College in these lawsuits. I mean, City College has not, the leadership has not chosen to join in these lawsuits with us. City College has chosen to focus on doing everything it can to fix any problems, because I'm not going to stand up here and say that I think City College is perfect in every way. I'm sure that there are some, issues that the college needs to work on, and they are focused on working on those, and we think that is great. And if everybody does their piece in this kind of giant moving puzzle, we really believe that City College will be able to stay open and to thrive and to continue providing this incredibly valuable service to all of you and to the whole city.